Mr. Stroll, did you have a chance to look at the jury instructions?
Yes, Your Honor, I did.
Other than objections previously stated and discussed, anything else?
No, they seem to be identical to what we went over a little bit last.
Mr. Dunn, did you have a chance to take a look at them?
I did.
Other than what we talked about before, they look all right to you?
Yes, sir.
They're acceptable?
Yes, sir.
Okay. All right, what I've done is as far as the verdict forms are concerned, I've stapled the first 4 because they're 2 pages. The last is 1 page, and then I'm just going to paper clip them. So those will be quote unquote the originals that the foreperson would sign and date. Then I have 12 copies of the instructions, 1 for each juror. I also have 12 separate verdict forms. Those are stapled together because I figured they'd just thumb through them for each individual juror. And then what I'll do is when I get to it, I'll instruct the foreperson to kind of take care of these, and those would be the ones they would sign and date. And then what I'm going to do is after I read the instructions, the original copy of the instructions themselves, I'm going to go ahead and give to the clerk. So that'll already be in the record. And then when they're finished, we'll just collect the other sets and we can be finished with those. All right, so are we ready to proceed?
Yes, Your Honor, you did request that the laptop be reviewed and you
Oh.
want to hand it to Mr. Smith and let them look at it. We'll have it brought in by the bailiff.
Yes.
I don't know what time you wanted it.
Now would be good. And have you had a chance to look at it, Mr. Stroller?
The laptop, no,
Yeah.
sir.
Well, that's why I didn't bring it in earlier. He.
Was busy, obviously.
Yes, sir. So when you want it, we'll get it here.
Well, give it to Mr. Smith now, if you've got it.
Well, we're having it brought over tomorrow. Just the office here inside the.
Okay.
setting.
All right,
But
well,
we'll just bring it in and then we'll get it.
What I plan on doing is after this, I'm going to take another break,
Yes, sir.
10 or 15 minutes. We could look at that then, and that's also, ladies and gentlemen, obviously you're all very welcome to stay through the reading of the jury instructions, but a lot of times people don't care to listen to all of that. So sometimes what I have is a mass exodus out. So that's why I take the break. If you don't want to sit and listen to all of that, that's fine. But if you are in here when I begin, I would appreciate if you just stay seated. And it does take a while to read them. I suspect it'll take probably at least 30 minutes. So just so you know. And then we'll check the laptop at the next break. Okay, bring the jurors on in.
Jurors enter the courtroom.
All right, thank you, ladies and gentlemen. You can have a seat. We are ready to resume, and we will hear from Mr. Guy.
Thank you, Your Honor.
Yes,
Please
sir.
report.
Yes.
Counsel. Good afternoon. That defendant didn't shoot into a car full of kids to save his life. He shot into it to preserve his pride. Period. That's why we're here. Because of his actions, his inactions, his decisions, his choices. Jordan Davis didn't have a weapon. He had a big mouth. And that defendant wasn't going to stand for it. And it cost Jordan Davis his life. This case is not about self-defense. It's about self-denial from that defendant. Self-denial that's been refuted in every conceivable way by physical evidence, physical impossibilities, by eyewitness testimony, including his own fiancée, in every way. And when the defense attorney stood up here and told you that we have the law and he has the law, he left some people out. Jordan Davis is entitled to the law. Leland Brunson is entitled to the law. Tevin Thompson is entitled to the law. Tommy Storms is entitled to the law. And all 4 of those men are entitled to the truth. And that's what we're asking you for now. We don't want your sympathy. We don't want a lesser included offense. We're not asking for that. We're asking for the truth as you know it, now, in your heart, in your head, in your gut. You know, there's an old saying in the legal community, if the facts are against you, argue the law. If the law's against you, argue the facts. If they're both against you, put somebody else on trial. Isn't that exactly what the defense has done in this case? Remember where it started? Andrew Williams. Good for people like Andrew Williams, who have only a teenager's swimming CPR training, but who, when the gunshots rang out, turned into the parking lot, towards the gunfire, to see what he could do, to put his hands on a stranger's chest, to try to save him. Good for people like Andrew Williams. And he's going to attack the medical examiner, an expert. She doesn't know what she's talking about. That's what he just said. She doesn't know what she's talking about. How many hundreds of autopsies has she performed? And she doesn't know what she's talking about. The police officers who worked through the night, they didn't sleep through the night like the defendant did. He picked on them. He put them on trial. Detective Musser, Andrew Kipple, Officer Holmes, Officer Forster, were those incredible people? Were they? Yeah, that's the great thing about real life. Because on TV you can't see that. You can't sense that. But in a courtroom you can. Do you really think those people got it wrong? That they didn't do their job? That they didn't take their oath as law enforcement officers seriously? Do you think that after meeting them? After hearing from them? After they looked you in the eye? Do you feel that way? Do you? Think about it. It is the most powerful and oldest tool known to mankind. It's something that we use every day to make little decisions. And it's something that we use to make great, life-changing decisions. And it's the one thing that I submit to you, beyond anything else, lets you know that this defendant before you is guilty. Common sense. The common sense that tells you if Jordan Davis had a gun, that defendant would have never left the scene. If Jordan Davis had a gun, he would have called the police. If he was truly acting in self-defense, he wouldn't have been running from everybody. He wouldn't have lied to the police. He wouldn't have changed his story. So indulge me for just a few moments while I go through with you some common sense reasons why this defendant is guilty, as charged, not of a lesser. Wow. In every trial, for those of you who haven't been jurors before, there's one moment in every trial when the clouds gathered by the lawyers kind of break up and light in the form of the truth comes through and takes over the room. Was it not yesterday when his fiancée came back? Rhonda Rouer, the one who they made fun of because she had to be helped on and off the stand because the last place in the world she wanted to be was right here, sitting across from him. Miss Rouer, did he ever tell you about a weapon or a gun? No. No. In only a whisper, she said it over and over again. No. That fact alone, what does that fact alone tell you? The person closest to him on this earth, with him at the time he shot and killed Jordan Davis, to the hotel, at the hotel, back home, 2.5 hours. Did he ever mention a gun? Ever? No, he didn't. Did he call Ken Lescalais? No, he didn't. Did they talk about getting together because he had something to tell him? No, they didn't. Wow. His own fiancée told you that. His people, not ours. And to suggest that Jordan Davis was committing a crime or attempting to commit a crime, think about that for a minute. He said the state can't prove beyond reasonable doubt that Jordan Davis wasn't attempting to commit all those crimes. Think about it. Can you imagine if Jordan Davis was on trial for even the aggravated assault of Michael Dunn, and this was the evidence you had before you, because this is the evidence. Can you imagine that? It's inconceivable to think about. That's how strong the evidence is against this defendant. That's why it's not a self-defense case. That's why it's a murder case. He didn't have to shoot him. He decided to shoot him. He chose to shoot him. And for the worst of all reasons, 10 times. Because he wanted to shoot them. Think about it. Common sense. Tommy Storns, 19 years old. There's a shotgun in the car. Are you kidding me? Are you kidding me? He's going to stop anywhere close to there? Are you kidding me? They didn't know Jordan had been hit. They didn't know anything. He's not stopping. He's not stopping. He's driving off to somewhere where it's dark, somewhere where he can throw the gun out. Look where he stopped. In a plaza on Black Friday before 8 p.m., full of cars. He had just been to the gas station, full of people. Seriously? Tommy Storns? The guy on felony probation, in violation of his curfew, is going to stop the car and go back? He's going to stop in that parking lot? Does that make sense at all? Of course not. Of course not. Jordan Davis is threatening to kill the defendant, has a firearm, starts to get out of the car, and then says for the first time, we learned, this shit is going down now. Think about it. All of his energy is trained on who? Michael Dunn. He's got a firearm in his hands. He's outside the car. And Michael Dunn is going to reach over, open the glove box, pull out a firearm, take it out of its holster, put a round in the chamber, and have time to shoot. Doesn't happen. If Jordan Davis had a shotgun and was as mad as only the man on trial claims, Jordan Davis would have shot him right there. You really think he would have let him grab a gun after all of that? Does that make any sense? Of course not. Inescapable. Absolutely inescapable. There's lights. There's people. He's in the first parking space right next to the door. And beloved Rhonda is inside the store. Why on earth, if there was a gun in the other car that had left, was gone up Southside Boulevard, why would he leave? Why would he leave? The same reason that Tommy Storms came back proves to you he shouldn't have left. That was the safe harbor with lighting and people like Andrew Williams and help. Why would he leave if there was a gun in the car and he hadn't done anything wrong? He left the scene. Why would he call the police? Isn't that the first thing someone would do if their life had really been threatened and they'd had to use deadly force? Shooting into a car with 4 human beings inside? Isn't that the first thing a person would do? 911, it's 3 digits. That's why they make it that way. Isn't that the first thing someone would do? He never did. Ever. The defense attorney kept saying he didn't call the police until the next morning. No, he didn't call the police. The police called him at his house. He didn't call Ken Lescalay from the Department of Agriculture. He didn't say, Ken, I need to talk to you when I get home. He said, Rhonda's not feeling well. We can't go out tonight. He didn't call the police ever. Does that make sense? Members of the jury, this isn't a complicated case. And while the state of Florida versus Michael Dunn may go down as a horrific case, it'll never go down as a close one. Not only evidence that you have before you, real life evidence. All these exhibits and all that testimony, 27 people on behalf of the state of Florida. 204 exhibits. Why would his story have changed so many times? And I'm not going to go through them with you because Miss Wilson did. But why would it change? Why would it change what Jordan Davis had said? Why would any of those things change? Why would it change between the music was on when I pulled up to the music wasn't on when I pulled up? Think about it. Think about the progression of his account, of his story to law enforcement. In the letters. Compare the interview to the letters. It changes constantly. Why? The truth doesn't change, ever. It is what it is. Why does his keep changing? He wants to complain about the doctor who got down here and showed you, didn't tell you, she showed you how it happened. How his leg was up when he was leaning over. She showed you a picture of his liver. because there was an angle through it, like the bullet went through his chest. And the dowel rods came through the door. They didn't go through the door to the outside of the car. They went through the door to the inside of the car, where Jordan Davis was. She took you through every single gunshot. She did it with herself. She did it with the mannequin. She did it with the photographs. And she is the expert. We talked about the plastic from the door inside the car. It's not on the ground. They checked the ground. They found the little tiny fragments of metal that shattered from the bullets. They checked. No plastic. No glass. No nothing. Jordan Davis's wallet. Jordan Davis's blood. And Tommy Storm's coat. He's hysterical. He's enraged. He's getting out of the car. The cars are so close that you can't open the door. Yet there's no damage to the defendant's car. None. None. Think about that. He wouldn't have banged the door, this enraged, psychotic kid with a shotgun when he got out. If the door was open and the car was backing up, it wouldn't have made a line all the way across that door. And think about this for a second. Think about this. Jordan Davis is sitting down. If he had opened his door and the cars were so close together, like everybody said, how would he get out? Wouldn't he have to go like this through the door? Well, he wasn't shot here. He was shot here. That's how you know he wasn't outside the car ever. Just like Steve Smith said, and Leland Brunson, and Tevin Thompson, and Tommy Storms. The physical evidence is irrefutable and corroborated by the eyewitness testimony, the people who were there. He was afraid of retaliation, so he parked out front. And he left his gun in the car. And he took Charlie outside. He wouldn't have called the police ever if he was really afraid, if he was sitting by the window looking down, waiting for every car to drive by because it's the red SUV, who, by the way, didn't follow him, who stayed at the scene. Does that make sense to you? Does it? Of course not. The defense attorney mentioned that he wants to talk about interest in the case. Sean Atkins got some game time, lost some game time. Chris LeBlanc got his little misdemeanor warrant put back on the calendar for a driving while license suspended. Tommy Storms didn't get violated because he was out with a friend when the friend was shot and killed. He forgot somebody. Who has the ultimate interest in the outcome of this case? Who? Is it Mark Musser? Is it Andrew Kipple? Is it any state witness? Of course not. That's the only person in this courtroom with an interest in the outcome of this case. And the only person whose story keeps changing. They said it's about common courtesy. The defendant couldn't get a common courtesy. That was his testimony. Why did you leave? After you learned at 1 o'clock that the boy inside the car was dead. He wasn't just hit, he was dead. Didn't matter to me. Self-defense is self-defense. Didn't matter to me. Let me suggest to you, it mattered to somebody. Is that not a common courtesy? When a person shoots into a car of other people and learns that somebody's dead, maybe make a phone call, maybe. And they want to talk about common courtesy. That's the way he left Jordan Davis, who, as Miss Wilson said, had no chance. No chance. A waking nightmare, the defendant said. How many times did he say it yesterday? Couldn't stop saying it. It was a waking nightmare. Well, how about a real nightmare? How about Leland Brunson reaching over and real blood appeared on his hands? His best friend's blood appeared on his hands. That's a nightmare. Tevin Thompson, Tommy Storms are living real nightmares because of one man. The SUV was gone from the parking lot. The defense attorney said for 3 minutes. I'll ask you to use your collective memories or your notes. Sean Atkins said it was gone for 1 to 2 minutes. Andrew Williams said he was at the intersection when he heard the gunshots, and by the time he got into the parking lot, it was 1 to 1.5 minutes, and the SUV was coming back. Think about that. He said the boys didn't tell the police, the detectives, that they left the plaza. They most certainly did tell them they left the gas station and went to the plaza and came back. They most certainly did that night, the night of the shooting. They talked. The LeBlancs are at fault because they couldn't see on both sides of the car. Think about that argument, about whose fault it is that the plaza wasn't searched. Had he gone to the police, had he picked up the phone, had he done anything and made his claim, they would have gone to the plaza. But where did he go? Home. Where did detectives go? To his home. The detectives were down there because of him. That's why they weren't searching the plaza. Whose fault is that? And think about it. Think about it. They're talking about a shotgun. Look at the photographs. I'll get to it in a minute. The aerial photograph, you remember. Think about where they stopped. Could they really get a shotgun out of the car with nobody noticing? Did they really think at that time of day, with the lighting and the people driving by, that they could take a shotgun out of the car and hide it somewhere there? And we do have witnesses, two more independent witnesses who didn't see anything come out of the car. They saw them look into the car. Does that make sense? Does it make sense? Remember where the dumpsters were? On the far side of the gate gas station, behind the right side. Did anybody say any of the boys went over there? And that's just inconceivable too, that after they got back and everybody surrounds the car to look at Jordan Davis, that they somehow snuck a shotgun out then? Gangsters. That's a telling word, label, that he used to describe the people, gangsters. Jordan Davis, 17-year-old Wolfson High School student, is a gangster now because the music was up loud. So is Leland. So is Tevin Thompson. So is Tommy Storms, because the music was loud. Now they're gangsters. Thugs, he said in his interview, in his letter. Thugs, waiting for the thugs to come back. Really. You met them. You've met them now. It's your call. Are any of them thugs or gangsters? That's a picture of the gangster thug. How about that statement to the police? Another thing that he had no answer for, no reasonable answer. Michael Dunn has an excuse for everything, but I'll submit to you an explanation for nothing. Not why he left the scene. Not why he didn't call the police. Not this. I can't justify it. He knew he couldn't. He knew it then and he knows it now. It can't be justified. It's not justified. It was never justified. Not any of the gunshots were justified. You'll have those pictures back there. But just think about it. That car driving away and the defendant getting out of his car to reposition himself, to get better aim, to pull the trigger again, not at random, with remarkable accuracy. And I submit to you, definite intent. That's the photograph I was talking about. The phantom stick or the gun. Those are the two areas that the gun disappeared from. The defense attorney said, well, the cousin came up there. Was there any testimony about a cousin being at the scene, coming up to the scene? Or was it Tommy Storn's aunt who owned the car to sign the consent form to search the car? Tommy Storn's cousin never came to the scene. Those were the words that Stephen Smith heard, and they picked on Stephen Smith, the contractor who was getting the fountain drink. That's what he heard. Do you think he just made that up? And Stephen Smith, is he in on the conspiracy too? With law enforcement, with the medical examiner's office, with Brevard County, with the LeBlancs, with Andrew Williams, with the crime scene technicians, with the perimeter officers? They're all in on it. Steve Smith's in on it. Did he just make that up? Did he? Or is that what he heard with his two ears that drew his attention to something he'll never, ever forget? Defense attorney complained about what the detectives said to the defendant. Well, let me assure you of one thing. What the detectives say about the law is not the law. The law comes from His honor, and only His honor. And you all have it. That's what you work from. Not a technique or something that they said to the defendant to get any response. Judge Healy will read to you the law in this case. He talked about the inconsistencies, picking on, attacking someone else other than his client, the state witnesses. And we talked about that. It's not like TV. It's not. And y'all know that now. In real life, there are inconsistencies. If those three young men had come in here and given you the exact same account, then I would submit to you, be careful. That didn't happen. In real life, people don't remember everything exactly the same. But what did they remember? That was corroborated by the physical evidence. That was corroborated by the other witnesses. That were corroborated by his actions and his inactions and his consistently constant self-serving statements. The defense attorney spoke about his witnesses, the people who thought he was peaceful. Think about them. Who were they? 3 of them were friends of his parents. One of them was his friend from years ago. They used to work together years ago in Jacksonville, the strange town. Were any of them with him that night? No. Had any of them had any extended contact with him prior to November 23rd, 2012? No. Had any of them ever been in his head when he heard that kind of music in that situation? No. I'm not going to spend a lot of time on this because you all have heard it 3 times now. Reasonable doubt. But let me just ask you. When Judge Healy reads you that instruction, think about it. And if any of you get back there and start saying, it's possible this happened, maybe this could have happened, I could force myself to believe that. That's not the law. Bring that person back. Use that definition as guardrails for your deliberations. And the reason it's beyond a reasonable doubt is because justice doesn't require perfection. It requires the truth. And do you not now have that? After all of the testimony and evidence in this case, and your common sense. It was the very last question Ms. Corey asked you last week. And now you know why. It was the most important one. Will you all use your common sense? The suggestion was made that we raise our voices, that we want sympathy for Jordan Davis, for his family, for the 3 other young men who are victims. We're not asking for your sympathy. And don't misunderstand the prosecution of the case. Your verdicts in this case will not bring Jordan Davis back to life. Your verdicts won't change the past, but they will forever define it in our town. What is that? What is that? At 7:38 on a Friday night, when a group of boys are listening to music, having struck out at the mall with the girls, heading for another mall, the day after Thanksgiving, and they're listening to music loud. And somebody gets offended, and somebody challenges one of them, and they get an answer back when they do. An answer back from somebody 30 years their junior. And they pull out a gun at point blank range, so close the doors couldn't open, and start firing. And the driver backs up, and they keep firing. And the driver pulls off, and they keep firing. What is that? I'm going to leave you with one more quote. And that is, to the living we owe respect, but to the dead we owe the truth. Jordan Davis, Jordan Russell Davis, 17, forever. As they had done so many times, the 2 young men were side by side. And because of that defendant, it was for the very last time. This is the dead. Physical evidence that cannot be explained away, that cannot be refuted. The words from his own mouth, captured in the memory of a stranger. Words of intent and words of hate that he can't now take back. In the indelible memories of all of those people he made witnesses and brought here. This is the truth. Thank you for your time. Thank you, sir.
Thank you, Mr. Guy. Ladies and gentlemen, what I'd like to do is just give you a 10-minute quick stretch break. When you come back in, I will begin reading these jury instructions to you. So if you'll just take 10 minutes, don't discuss the case among yourselves, and we'll see you back in about 10 minutes, please.